Hello and welcome. My name is Jane McAdam and I'm a Scientia Professor of Law and the Director of the Evacuations Research Hub at the Kaldor Centre for International Refugee Law at the University of New South Wales. Together with my colleague from the Hub, Dr. Thomas Mulder, we would like to thank you for joining us for this speed briefing on our new policy brief about foregrounding displacement in the proposed treaty on the protection of persons in the event of disasters. We would like to acknowledge the traditional owners of the lands on which we meet today and pay our respects to elders past and present. In this speed briefing, we will introduce you to the 4 core recommendations of our policy brief and explain why we believe that displacement and the needs of displaced people ought to be given more prominent attention in the treaty text. We should be clear from the outset that the recommendations themselves are very technical, given that they focus on potential language for a treaty, but the policy brief itself provides the broader context for them. Nearly every second, someone, somewhere in the world, is displaced by the impacts of a disaster. Climate change amplifies the frequency and severity of extreme weather events, like cyclones and floods. And it also aggravates slower onset processes, such as droughts and sea level rise. This means that disasters will worsen and displacement will likely grow. In 2027, states are expected to adopt the first ever global treaty on the protection of persons in the event of disasters. It will be based on the draft articles on the protection of persons in the event of disasters, which were adopted by the International Law Commission, known as the ILC, nearly a decade ago. According to the UN General Assembly, the new treaty aims to address the need for a comprehensive global legal regime to better address the protection of persons in the event of disasters. And the treaty will seek to promote international cooperation between states in the areas of disaster risk reduction, including disaster prevention, mitigation, preparedness, response, recovery, and rehabilitation. Governments have until the end of 2025 to submit proposed amendments to the text of the draft articles. These will be used to prepare a consolidated text for treaty negotiations, with the intention of adopting a legally binding instrument by the end of 2027. Curiously, the ILC draft articles barely mention displacement at all. This is odd, given that their impetus was the 2004 Indian Ocean tsunami, which left more than 1 million people displaced. In the intervening decades, disaster-related displacement has continued to grow. The latest figures show that nearly 70% of global internal displacement in 2024 was linked to the impacts of disasters. That is around 46 million displacements. This is a trend that has been relatively consistent for more than a decade now and is likely to increase with climate change. Although mass displacement is mentioned as a possible defining characteristic of disasters in the draft articles, the absence of specific attention to the rights and needs of displaced people is striking, as is the role that evacuations and planned relocations can play in averting harm. Our policy brief argues that the new treaty should explicitly address the issue of displacement. This is essential to fully realise its purpose of facilitating more effective responses to disasters and the reduction of disaster risks, so as to meet the essential needs of people concerned with full respect for their rights. We note, of course, that people's needs are diverse and disasters impact different people differently. Displacement can generate particular risks for individuals and communities, as well as exacerbate existing risks associated with disasters. Specifically, the policy brief recommends that the new treaty should, firstly, expressly acknowledge the risk of displacement in the context of disasters. Secondly, expressly acknowledge the life-saving role that well-planned evacuations and/or relocations can play as protective disaster risk reduction measures. Thirdly, it should expressly acknowledge states' duties to protect the human rights of displaced people. And fourthly, it should expressly acknowledge that assistance with evacuations and providing access to humanitarian and/or protection visas can be forms of international cooperation. Before exploring these more fully, we want to provide a caveat. In moving towards a treaty, states have been asked to focus on the amendments they would make to the existing draft articles as they currently stand. For that reason, we've taken a similar approach in the policy brief. But we also note that the draft articles are just the starting point, and the treaty could potentially end up going well beyond that text. We've therefore provided some examples in the policy brief of how and why states could go beyond the existing framing. And we've set out a range of frameworks that address displacement in the context of disasters, which provide very useful and detailed guidance. I will now turn to my colleague, Dr. Thomas Mulder, to explain the recommendations more fully.
Thank you. As Jane has already noted, the draft articles refer to mass displacement as a possible defining characteristic of a disaster, but do not mention displacement otherwise. We argue in the policy brief that by including express references to displacement, the rights and needs of displaced persons would be more clearly recognized as a core part in disaster risk reduction, response, and recovery. And this aligns with the views of some states that the treaty must reaffirm the importance of a people-centered approach and human dignity, and meet the essential needs of affected persons to ensure the protection of their rights. Therefore, our first recommendation is to incorporate express references to displacement in the preamble. We suggest that two clauses of the current preamble of the draft articles should change to the following. Considering the frequency and severity of natural and human-made disasters and their short-term and long-term damaging impact, including the displacement of people from their homes or places of habitual residence. Fully aware of the essential needs of persons affected by disasters, including displaced persons, and conscious that the rights of those persons must be respected in such circumstances. And the ellipses here indicate that other groups who face particular risks in the event of disasters could also be included here. Our second recommendation is to expressly acknowledge the life-saving role that well-planned evacuations and/or relocations can play as protective disaster risk reduction measures. Evacuations and planned relocations are increasingly a key component of national and local disaster risk reduction strategies designed to safely move people away from anticipated or immediate threats to save lives and minimize exposure to harm. While planned relocations are less common and more complex, many hundreds of examples have been documented around the world. Although the draft articles don't refer to evacuations and planned relocations, they were mentioned in background documents as examples of disaster preparedness activities and measures that could protect human rights. We argue that integrating evacuation and relocation planning into disaster risk reduction strategies is imperative for states to fulfill their responsibility under international law to protect persons in the event of disasters. This is because well-planned evacuations and relocations may avert riskier spontaneous displacement. We therefore recommend that evacuation and relocation planning should be expressly included in the list of disaster risk reduction measures set out in Draft Article 9, Paragraph 2, so that it is clear that they can be a part of a planned preparatory response. We do so to emphasize the need for planning, because without it, evacuation and relocations can create further risks including separation from family and community, physical harm, disruption to lives, livelihoods, and social networks, and lack of access to adequate assistance. In particular, this means that states must consult fully and effectively with affected communities to co-create evacuation or relocation plans, paying attention to the ways in which social, institutional, and contextual factors can impact particular individuals and groups. Our third recommendation is to expressly acknowledge states' duties to protect the human rights of displaced people. The draft articles contain high-level statements affirming that states must respect and protect the inherent dignity of the human person in the event of disasters, and ensure that human rights are respected and protected in accordance with international law, with the needs of particularly vulnerable groups taken into account. Given the risks inherent in displacement, it seems prudent to include an express reference to the need to protect the human rights of displaced persons. However, people's needs are diverse and disasters impact different people in different ways. Although the ILC decided against listing particular groups in recognition of the relative nature of vulnerability, displacement not only generates new risks, but can also compound and amplify pre-existing risks that threaten the rights of displaced persons and others. We therefore recommend that the treaty includes a non-exhaustive list of persons who may find themselves at particular risk in disasters, including those who are displaced. In line with that, Article 5 should be expanded, as shown in bold, to read, persons affected by disasters, including those who are displaced, are entitled to the respect for and protection of their human rights in accordance with international law. And the ellipsis in this recommendation indicates that other groups who face particular risks could be listed here as well. An express acknowledgement would draw greater attention to the specific needs and rights of displaced persons and promote a rights-based approach, reinforcing the importance of protecting affected individuals during their displacement and of securing durable solutions that uphold their dignity, safety, and long-term well-being. Should states be willing to address the rights of displaced persons more fully, we cite in the policy brief specific instruments and frameworks that provide detailed guidance on protecting the rights of displaced people in the context of disasters and climate change. Our fourth and final recommendation is to expressly acknowledge that assistance with evacuations and providing access to humanitarian and/or protection visas can be forms of international cooperation. States affected by a disaster have a duty to ensure the protection of persons and provision of disaster relief assistance. In fulfilling this duty, states must cooperate amongst themselves, with the United Nations, with the components of the Red Cross and Red Crescent movement, and with other assisting actors. They must seek external assistance if a disaster manifestly exceeds its national response capacity, and they must not arbitrarily withhold consent to any assistance that is offered to them. Currently, Draft Article 8 sets out a non-exhaustive range of forms of international cooperation. In their discussions, however, states have suggested that other examples could be added to this provision to promote additional clarity and certainty. In light of that, we recommend that providing assistance with evacuations and access to humanitarian and/or protection visas should be included as forms of international cooperation in Article 8, as is shown on the screen. Cooperation in response to disasters includes humanitarian assistance, coordination of international relief actions and communications, assistance with evacuations, including across international borders, providing access to humanitarian and/or protection visas. and making available relief personnel, equipment and goods, and scientific, medical, and technical resources. This could also include assistance with cross-border evacuations, particularly where a disaster overwhelms national response capacities or people need urgent medical assistance. In such cases, third states and assisting actors may cooperate by providing safe passage, transportation, and temporary refuge for evacuees. This support may also include coordinating logistics, establishing legal frameworks to permit entry and stay, and delivering essential services upon arrival. We also argue that humanitarian admission and stay, flexible and expedited processing of regular visa applications, and/or waivers of normal visa requirements should also be recognized as important tools in this context. In some cases, people may qualify for international protection as refugees or beneficiaries of complementary protection. Finally, more durable migration opportunities can also play an important role in enabling people to move away from existing or anticipated harms in a planned and proactive manner.
We hope that this overview has helped to show the importance of foregrounding displacement, evacuations, and planned relocations in the forthcoming Treaty on the Protection of Persons in the Event of Disasters, particularly given the increasing frequency and severity of disasters exacerbated by climate change and the risks they entail. By doing this, the treaty would better address the realities of disaster-related displacement, ensuring that the rights and needs of displaced people are at the forefront of disaster risk reduction and response efforts. This approach would not only align with existing international principles and frameworks, but would also reflect the growing recognition by states of the impacts of disasters on displacement and the fundamental importance of safeguarding people's human rights. Thank you very much for joining us.